Good morning, Europe, and good afternoon, Southeast Asia. I'm excited to welcome you to their webinar, which is brought to you by the Southeast Asia IPR SME Helpdesk project and the Center for International Intellectual Property Studies. My name is Nora. I'm the project manager for Southeast Asia IPR SME Helpdesk project, and I will be today's webinar coordinator. I would like to quickly introduce you for our outstanding speakers who will be sharing insights with you during this session today. So here with us, Tobias Denk, Senior Researcher at the IP Business Academy, Professor Dr. Alexander Wurzer, Professor for IP Management at the Center for International Intellectual Property Studies, and Mr. Manh Tran, external expert for the Southeast Asia IPR SME Helpdesk project and country managing partner at Baker & McKenzie Vietnam International. Before we get started with the presentations, let me quickly introduce you to the housekeeping rules to make sure that this webinar goes smoothly for everyone. Keep in mind that today's webinar is recorded and it will be available online. So if you want to access the presentation or listen to the recording, then you will find it on our website to download. Keep in mind that you can type in and send us any questions or comments through the question mailbox throughout this webinar session, which will be discussed at the end of the webinar during our Q&A session. We look forward to a live interactive discussion, so please feel free to ask anything that comes to your mind related to the presentations. And a quick overview to discuss the agenda. So I will briefly introduce you to the IPR Helpdesk project. After Mr. Tobias Denk will mention you what CEIPI is doing, and then we will go ahead with the two presentations on Industry 4.0 by Professor Wurzer and Mr. Hung. And at the end, we will have a Q&A session. So before we dive straight into the topic, just a very quick overview on what we are doing. So the Southeast Asia IPR SME Helpdesk project is an initiative of the European Commission to support small and medium-sized enterprises to protect and enforce their intellectual property rights when they come to Southeast Asia. All services offered by the Helpdesk are free of charge. So on this slide, you can see the type of services. We have an inquiry helpline, so companies can get in touch with us to ask any IP questions related to Southeast Asia, and we will get back to them within 3 working days. We offer publications online on various IP topics, industry-specific topics, or also based on different IP types, so you can check it out on the website, download it, read it through. We also offer online trainings, webinars like today's session, and on-site trainings as well, for example, in Vietnam where we can. Otherwise, these days, most of our activities happening virtually. And we have some interactive learning tools such as e-learning modules to learn about IP in a more interesting way. And without any further ado, I would like to hand over it to Tobias. So Tobias, the floor is yours now.
Yeah, so thank you for having us. So I'm Tobias Denk. I'm the research program coordinator at the IP Business Academy. So the IP Business Academy is basically the blog of the IP management education at CEIPI, and we have two types of blogs. So on the left side, you're seeing our LinkedIn blog, and on the right side, you're seeing our webpage with the blog at the ipbusinessacademy.org. And there we are informing you about all our activities. So our programs at the CEIPI, but also webinars like this, and we are always providing you with additional information about the events. And we are also giving you case studies and news about the industry best practice of the companies in Europe, but also worldwide. And we are also hosting every Wednesday, every week, a talk on LinkedIn Live with an IP expert about the new pressing topics in IP management. And we are hosting every week an event with a person from a different country. So last Wednesday, it was an expert from Ireland, today from Germany, next week from India. So we are giving you a lot of information and interesting material about IP management. So the person responsible for the content is basically me, but also my colleague Pamela Beershoven for the IP business talks. Yeah, so that's what we are doing. We are also giving you additional material there for this event today. And yeah, then thank you. I hand over the microphone to Professor Wurzer, so you can start with the
Thank you, Tobias. So we will make Professor Wurzer presenter now, so you can share your screen and help us to explore more about Industry 4.0 and IP. Thank you. The floor is yours now.
Thank you very much. I try to do so. Okay, you see my slides?
Yes, it's on full screen. Perfect. Thank you.
Wonderful. Okay, hello from Munich, Europe. So I'm from the CEIPI. We are the Education Center for IP Professionals and European Patent Attorneys. Originally located in Strasbourg, but we are already locked down, and so I'm sitting at home, and I'm absolutely happy to present you what we are doing there, what we do at the IP Business Academy to provide you with that information. Basically, the issue is that we have right now here in Europe, 1/3 of all patent applications are so-called digital patents. We call patents digital patents when it is not just that they deal with digital technologies, it is also so that they protect digital elements, objects which have an economic value, for example, use cases, or apps or customer journeys, customer experience. And so that makes them tricky, though they are not that kind of normal technology patents as you would expect them. And for example, we have trainings here about blockchain patenting, artificial intelligence patenting, also IoT technologies, whatever you can imagine, which is digital and have a significant impact to economic issues, to business models and to use cases. And here are the figures to 2017 from our colleagues in Geneva from the WIPO. What we are doing is, first of all, education and information providing. So one of our newest baby from last September is a new fully distance learning program and university diploma in IP business administration, which is pretty much dedicated to digital technologies and the digital transformation. So how to design digital solutions that they become protectable. We publish many case studies about the industry practice. They are free of charge. Everything is available via the IP Business Academy. Also, the whole background information to that presentation is also available there. And we cooperate with all my PhD students and former students here with that companies on the left side by developing this kind of knowledge. And this is a wonderful example. It's not so far it is not granted, but it shows how people think when they apply for use case patents. So patents which are not thought out of a technical issue, which are thought out of the fact that I would like to protect a use case and a digital object which has an economic impact. And this is Signify. Signify is a fascinating case study which we have also there available, because Signify is really, it's a $6 billion business, and what they are doing is they're licensing out use cases based on light. So they use light, so it's not the technology of light per se, this LED lights, it is the question how to apply this kind of lighting source to solve certain problems and issues. And here, for example, this is a patent application, PCT application, and this is just one of 2,800 which they have currently under license in the licensing program. And this is this enables companies to evacuate office buildings. Okay, so you have a variable population of people in the rooms in the building. You have a variable population of objects like desks or chairs. And then comes the time you have to evacuate the people out there, and then you use the lighting system and sensors and an algorithm to optimize this kind of evacuation. And obviously, such a pattern application does not come out of the thinking of technological solutions of technological problems. It comes of the willingness to offer to third parties licensable licensing objects which can be used and applied in their business. And this leads us to a general logic how the digital transformation happens. The first step is the so-called digitization. So the English has 3 different terms and they have 3 different meanings. And interesting is that the role of patents are completely different in that 3 phases of the digitalization. So the first phase is the digitization. That means I come from an analog format and go to digital. But the business and everything is the same. So it's like so far you buy the vinyl LP for listening to music, and now you are buying and selling a CD. So it's the same business and it's the same thing. You need a player, you have a physical data object, which the media is physical, and you have to put it into a player to listen to the music. So we just switch from analog to digital, and this is when you put sensors and actuators and analogs and analytics and software into a machine. Okay, this is just going from analog to digital. You optimize the functionality of the machine. This is the starting point of the digitalization, and we call that digitization. And here patents are just for protecting functionality. So then the second functionalities of the machine. The second stage is that this digitalized machine now is acting in a digital environment. Okay, so this is when you use iTunes to download files and music files, and then you can listen on your edge device wherever you want to the music. It's still the same transaction. So you buy an object, here a file, but the file is not physical, and the process is digitalized. And here, for example, we have a working machine like a harvester, which collects data about the soil to optimize later on, for example, the fertilization, the artificial fertilizer for that piece of land. So we have digital processes and machines acting together in digitalized process chains. And here patents have a different function. So patents are for protecting the data models, the representation of the reality, the question of how to exchange data, interfaces. That is what I am protecting here, and not the functionality of the machine itself. So I don't look at isolated machines, I look at ensembles of machines and how they work together, and so of the job. And this phase is called digitalization. And then the final phase is the digital transformation. So here we see really new ways of making business. So that would be a Spotify, which comes to you and say, look, you don't buy music. What you're doing is you get access to music, and I don't care on which device you listening to it, when you do that, where you do that. I just give you the access, and I'm paying a flat fee for having access to data, to music data. And so that's really a new deal and a completely different way of making the business. This is digital transformation. That's the final stage. And here we are really doing new kinds of business based on the first 2 phases. And we call that digital transformation. And patents have here the role of securing interoperability, so that totally different systems can interact with each other, and the so-called curation. We call that typically algorithmic curation. That means the platforms have to make sure that the quality, the kind of information which is dealt there has a certain quality and is the right thing for the right people. So totally different functions for patents, roles, what they have to do to be helpful within business. So when we come to the different examples which I would like to present you here, which are all later on available via the IP Business Academy. You can click there to the case studies and to the videos and everything. Just a short introduction to that case study. So Netflix is a wonderful example. It's a streaming platform. And when I ask somebody, what do you think, how many patents has Netflix? Or what, Netflix? It's a software-based content streaming platform. What should they patent? So what they patent is, for example, the customer experience. And the customer experience, because once they enter, so it's a PhD work on which one of my PhD candidates right now working, and we publish a paper right now. It's a fact that Netflix in the early years had not enough bandwidth. So the problem is, once you switch from the classical broadcast television to Netflix, you don't want that Netflix always showing you the buffering sign, right? So I'm not ready, just wait a little bit. So when you do that too often, it is clear a bad customer experience, and the consequence is that people won't switch to that platform. So what we see is that they use a layer structure. Down there is the physical product. Then we have the physical product, so to speak, is the edge device where you are watching the program. And then we have actors, sensors, connectivity, analytics, and finally what you are seeing is the digital service. And they use the whole structure to make sure that what you see at the end is a very convincing customer experience, and that you switch to Netflix and say, this is an alternative for me compared to watching classical broadcast TV. So, and this is the next stage. I just recommend to watch that video. We don't have the time here to do that. I recommend to you watch the video later on IP Business Academy. So we present that to you. It's a cooperation between the Chinese Tencent and the British Myriad. So Tencent, you know, is Netflix and Google together in China, and they have the problem that they have to collect money to produce content. And because of coming free of advertisements to the customers, they have the problem that they have to integrate in their program advertisements, but nobody should see that. And we call that, you know, that product placement. So what they do together with the AI experts from Myriad, they manipulate the pictures, the movie pictures, after that is already produced. So they can show you fully integrated native advertisement, and you don't feel that this is advertisement once you watch the original movie. And they can do that wherever they want, wherever they broadcast. They can show you manipulated pictures to your individual interest. So this is radical individualization of products, and this example, by the way, has nothing to do with Tencent. So this is done everywhere, that you change the products after they were produced, once they are in the hand of the B2B or B2C customers. And again, they use the whole range of different levels between the physical world and the digital world to protect that use case. Another example is, again, it's published, you can watch it. It's also a B2C example here from ThyssenKrupp from selling a stair lift. So watch the video. The video explains everything what happens there. And again, they use the whole level structure to make sure that they can protect their use case. And again, these examples are right, the same thinking as it comes from the CEIPI case. It does not come from the improvement of the machine, it comes from the improvement of a customer journey and a use case. And this is what we want to protect. And finally, we see that the forbidding rights, the intellectual property, are used to make sure, it's like a fence, okay? And they are used to make sure that the competition does not come in the same position to offer customer benefit to the customers. That's the trick, okay? It's not so much focused on the invention itself or the cornerstone of the technical solution which I offer. It is about what do I have to avoid, because we have only forbidding rights, that third parties could come in the same position in terms of customer benefit to the customer, to the target group. And the digitalization helps us to do so because of that levers which we have, these layers on top of the physical products. So saying in a nutshell, you could say everything what already exists will now be patented again, but with that levels on top, with that layers, to digitalize them and to create new customer benefits. And it is offered in an ecosystem. So all these examples don't come isolated. The machines, the gadgets, the devices are not isolated. We have to think them in an ecosystem because the benefit for the customers comes from an ecosystem. And that means that we need patents which ensure that once our business ecosystem is digitally transforming, we make sure that we have the right position in that. And that happens around the globe. And no country, no region can be separated from that. And in addition, what we see is that it helps to start with digital thinking, because for example, our European companies, they are pretty much focused on that physical layers because they produce physical products over the last 100 years and they optimize them. So everything what they are thinking is from down there and adding that layers. For us, the problem is that these digital natives, these new entries, they come with a digital mindset, and that means they file patents on architectures, on implementations without a concrete knowledge of that physical layer down there. For them, the physical layer is just an infrastructure. And so they patent up their concepts and architectures and infrastructures. And once you climb up the ladder in reality, you find that, oh, there are many companies which have condition monitoring, preemptive maintenance, and but they don't produce machines. No, it's not necessary to do so. Okay, so coming from there has a huge first mover advantage. And the good news is, and we explained that in many papers, that you could use, and all the case studies, it's also explained there, you can use that structure, that taxonomy of digital patterns to apply that to your concrete business model. And we have many, many examples out there in which the way is explained how to develop digital business models to be protected and free of third-party rights according to that taxonomy, which comes out of the analysis of thousands of digital patents. And one final example is the company Rittal, because Rittal is really in the core, in the heart of the industry 4.0 here in Europe, and they also produce in Asia, in China, for example, for Southeast Asia markets. And so what they're doing is they build switchgear cabinets, so the housings of switchgears. And so it seems to be quite a trivial product, right? So they are kind of, I don't know, IKEA for the industry. So they deliver the spare parts to make the casings. But what they do is they develop the logic of a digital twin for the production of switchgears to integrate the whole value chain. And the problem which they face is, or the challenge which they face is, that what you see here is that they come from a standard product. They are mass producer, right? But the problem is that the variants go up and up. So more and more, every switchgear becomes an individual solution, and the price acceptance goes down. So at the same time, when they rise the costs of complexity, the prices, the money which they get for every individual solution goes down. So obviously that's a problem. And what they do is they digitalize the whole production via this digital twin along the whole value chain. Okay, so this is the value chain of such a, so here you see a switchgear cabinet. Okay, there's the whole electronics and electrical engineering inside for a machine and production machine, for example. And what you see here is it starts by the commissioning, then it comes the order, the clarification, the project design mechanically, the electrical project design, purchasing and planning, the logistics, quality management, material management, production of the mechanics, then the assembly of the whole switchgear, and finally the wiring. And in the case study, you see many movies, how that works and what is the value chain. But the cornerstone, what I want to explain you is that they do that right now. The whole value chain is mirrored by a digital twin, and we collect the data over the different stages of the value chain in this variable digital twin, and then the machines which are makes, for example, the wiring, this data comes from that digital twin. And we developed and thinking a way of analyzing here on the one side the real world aspects, and at the same time the virtual aspect. So we have really a physical and cyber physical system. We analyze the whole business model on the resource perspective, on the market perspective, and based on that 360-degree IP strategy matrix, you can create dedicated objectives for the different aspects of the strategy. So how we manage risks, how we suppress imitation, how we design the market position, and how we can communicate our unique selling proposition. And after understanding that objectives, you analyze this cyber physical system. So here we have the real world, and here we have the digital world in terms of the digital twin. And you analyze then the interactions. Okay, the real world is, so to speak, boring. It is production like always. The virtual world is also, it's not boring, but typically not patentable because it's pure software. But the interaction between the two worlds, so the cyber physical system, is patentable. And you identify what are the specific objects, where are very interesting, tricky interactions between the real world and the physical, between the real world and the virtual world. And there you use applied already existing argumentations of problem solution combinations to get your patterns. And what you're doing there is a logic compared, again, it's more the same thing like this T, yeah, this taxonomy. This is a logic which is applied in all of the case studies developed out of hundreds of business models which were analyzed. That in all that business models you have always the typical application of digitalization logics. So you have the enabling logic, you have the simulation and mapping logic, the network logic, and the data and information logic. All the cases can be mapped on this structure, and these four logics are implemented with these 8 technical systems. And all these examples which we gave to you from all the case studies, they use that technologies, and they are well described And what they do is they improve the business model. Finally, on the right side, you have the market perspective. So you're enabling humans or you're enabling objects to get you to be more effective. Or on the left side, you remember that was the resource perspective. You have network logics like horizontal and vertical networking. So you lower the costs. That means you rise efficiency. So when we say you can protect a business model, we mean that what you can patent are the consequences of these logics, the application of that logics within their technical systems to either rise the effectiveness of the business model or lower the costs in terms of rise the efficiency of the business model. And that is a way of thinking, which means you start not with I have an invention, should I apply for a patent? You start with I have to analyze my business model and I have to ask the question, how could I improve that digitally, and what are the applicable logics which I could use to protect it, the improvement of my business model, to avoid that a third party, my competitor, could come in the same position to offer a certain customer benefit. Within the presentation, we have some examples here: German patent, European patent. What is patented there? Because typically the audience asks, so what is now at the end, what is really patent there? And we give you that examples. And also, by the way, here are also examples, numbers. You can watch, you can analyze that to get a grip on what is really happening there. Read the case studies, watch the videos, and you will go into that kind of thinking. And that's just one example of dozens of examples which we present you there. And you can learn that. So this is not black magic. You can learn how to think and how to apply this kind of thinking for your own individual business models and digital solutions. And for that, we developed a distance learning course. It's fully available, so you don't have to touch French soil to get that certificate or that university diploma. And each and every certificate, you can go for that every third month to learn what I explained to you. We have a joint cooperation here with the European Helpdesk. And the whole material is available to you once you enrolled at the university, and then you can watch and learn and teach yourself whenever you want, including, of course, interaction with the professors and teachers, that you learn how you create digital solutions to make them patentable and to exclusify, to protect your business models, your use cases, your apps, and so on, your digital solutions. That's it. That was 25 minutes, I hope, at least.
Thank you very much, Professor Wurzer. It was a very insightful presentation, and thank you for the live case study sharing. It's really good to see through the practical aspects. So I just would like to encourage the audience that if you have any questions or comments that you would like to share, please send it through the question box. And after the second presentation, we will be discussing all questions with our speakers. And now I would like to give the floor to Mr. Hung. So you will be able to share your screen with us. And also, if
Good morning, Europe.
Yeah, if you want to switch on the camera, Mr. Hung, it's up to you.
Okay, let me try to switch on the camera.
Yeah, it's just under the
Can you see me now?
Yes, I can see you. Please try to put the presentation on full screen.
Okay, I will do that right away. Okay. Can you see the screen?
Yes,
and
yes.
My web?
Yeah, I can see full screen.
Excellent. Thank you.
Right.
So good morning again, Europe. Well, thanks for having me here today. For today, I will touch upon the impact of the fourth industrial revolution technology on the IP law. And for that one, I will talk about a view on 4IR technology and how that will resonate with patent trend. And then I will touch upon a little bit about the impact of AI on IP law, and then the impact of IoT on IP law, and last but not least, I will talk about the impact of the 3D printing on IP rights. Before doing that, can I ask you a question? Have you registered any invention in Southeast Asia? Yes or no, or not yet, but intend to? You have about 20 seconds to answer the question, and then Nora will be very kind to show the answer.
Correct. So we will give the participants around 40 seconds. So you can let us know if you already have any kind of IP registered in Southeast Asia related to invention. And then we will share the result, and Mr. Hung will comment on that.
Interesting question. It just lets us know whether you have registered.
Yes, and there is no wrong, there is no correct or wrong answer. So feel free.
No wrong or right.
Okay. So I think we can share the result now. So
yeah,
what we can see is 24% of our attendees said yes, they have registered an invention in Southeast Asia. The majority said no, 68%, and 9% not yet, but intend to. So now the task is yours, Mr. Hung, to convince the ones who have registered. How should they proceed? Thank you.
All right. So thanks for your answer. I think in the next 25 minutes, I will try to convince you to file patent in Vietnam and Southeast Asia. And the reason why we should do so as soon as possible.
So, sorry for the interruption, but there's a problem with your camera. We cannot see you.
Oh, let me try again. Can you see now?
I think it's switched. I think it's okay now. It's switched off, but it's fine.
Right.
I see you. Perfect. Okay, good. Thank you.
Excellent. Thank you. Yeah, let's move on. I can't move the slide from my end, Nora. Nora, can you give me the control right?
Yes, you should be able to move the slide now. Try to
sorry,
go to...
I can't. Yeah. Or maybe you can take it back.
Okay.
Okay. Okay. All right. Here we go. So first of all, let me share with you my view on the 4IR technology and how that will resonate with the patent trend. As you can see on the screen, up to 2016, above 5,000 IoT patent applications were filed with the EPO, European Patent Office. And then we believe that up to 2025, then we expect that there will be up to 30 billion smart devices globally that are equipped with sensors, processor, and embedded software, enabling them to collect data and operate autonomously. I think this is quite impressive, as you can see from the diagram in the slide. So that means the 4IR innovation is really taking off now, not only in the region, but I think according to EPO, it's really impressive in even around the world. So the 4IR technology and patent trend here, let me show you some data. We talk about core technology, application domain, and enabling technology. And as you can see on the screen, application domain and it's really taking off. And enabling technology is also very fast tracking, and core technology is catching up there. And now let me go through one by one to explain to you what amounts to the concept of application domain, core technology, and enabling technology. So When we talk about core technology, we talk about hardware, software, and connectivity to make it possible to transform any object into a smart device connected via the internet. I think that is the short introduction of core technologies. So what about enabling technologies? It means analytics, security, AR, or position determination, power supply, 3D system, user interfaces are used in combination with connected objects. So what about application domain? As you can see from the screen, it means home, personal, enterprise, manufacturing, infrastructure, vehicles, where the potential of connected objects can be exploited. I think those are the simple definition of the application domain, core technology, and also enabling technologies. As you can see, all the data really uptrending. It's quite a good news. So here to give you some example, some figures about the patent application trend in Vietnam. So on my left-hand side, you can see the patent application filed from Vietnam and patent application filed from foreign applicants. So from 2007 up to 2017, so application filed by Vietnamese national applicants only accounted to 592. It's very nimble, simple, and humble number. At the same time, as you can see, foreign international patent application filed in Vietnam is almost 5,000 applications. So what about the registration in Vietnam? As you can see, that application accepted for prosecution in Vietnam is very humble for Vietnam application, but at the same time, for foreign international application, the ratio for acceptance is quite high. So even though, sometimes, people keep saying that, the patent filing from Vietnam is still very humble. So that's why Vietnam contribution to the world technology is still very humble and nimble. So I think there are many factors around that reason, but I mean for today, we will talk about, actually from 2013 to 2017, it really witnessed an average of 6.5% per year, and Vietnamese patent application only amount to 10% compared to foreign application. So let's walk through a case study by Bosch in Germany. As you can see that they introduced a concept called smart factory and smart manufacturing. So what amount to the concept of smart factory and smart manufacturing? It consists of machinery and components communicating with each other and minimum human control. So as you can see from the entire production process from start to finish, they have from production, marketing, and related services, everything is like in one pack. Include like mechanical and electronic components such as production facilities, robot, few devices, sensor. So it's around to 60,000 sensors are being used. And actuator, internet, interconnect, and also exchange information also applied here. So from here, we can see that a combination of the 4IR technology that open up to a lot of potential opportunity to make sure that they can achieve higher productivity, better flexibility, and the quality control is better. I think that will spurring further innovation in future. So this case study is cited from the Patent and the Fourth Industrial Revolution European Patent Office. So next thing we'll talk about the impact of the AI on IP law and what's the AI. So when we talk about the AI here, we actually talk about the deep learning and AI, artificial intelligence and machine learning. For deep learning, it really involves from machine learning uses a plurality of the AI algorithm. So for machine learning, we talk about uses example of input and output expected in order to continually improve and make decisions without being programmed, such as like some example I can take here like spam filtering, machine translation. A lot of people now use machine translation. Of course, sometimes the results comes up very funny as well. If you translate from Chinese to Vietnamese or like vice versa. or sometimes from German to Vietnamese, and it has something differently. Voice and text and image recognition is really important. That a lot of smartphone producer that using voice text like Siri for Apple, or like for face recognition for Apple and Samsung and other smartphone producer as well. So AI is a discipline of computer science that is aimed at developing machines and systems that can carry out tasks considered to require human intelligence. So next thing is the impact of the AI on the IP law and the challenge of the IP law. So as you can see, most of the law drafters in Vietnam and around the world, when they came up with an IP law draft, they only mentioned or was thinking about natural person, human. They have never thought about today if something happened like machine created work. So that's why very often practice go faster than law. So that's why law sometimes is like trying to catch up with with practice. So it's sort of like a mission impossible. For Vietnam now, actually, we are working with stakeholders in order to come up with more comments and input to amend the Vietnam IP law, and hopefully some of the concepts like IR, AI, or will be introduced for the first time in the IP law in future. So by and large, the current IP law system in Vietnam and elsewhere have long aimed to protection of the works created by natural person, human, not machine created work. But actually, I can take some example here. Like author can be granted the moral rights and economic rights over her or his work. So what about a product or work is created by machine? We will talk a little bit more in the next few slides. So there remain a lot of unanswered questions here when we talk about the AI and how the IP law will interact with the AI. The first question come to mind is whether AI be the author of the work within the existing IP frameworks. As you can see from the YouTube channel, some of the first music was composed by AI, and it's really amazing. But again, the question is whether AI is actually the author of the work or not. Likewise, the next question remains unanswered is who would be the patent author among the involved parties. So someday, if a patent is invented by AI, so the key question here is who will be the author? It will be the AI itself, or the person who owns the AI, or the organization, company who owns the AI. It still remains, unanswered. Assuming that the AI infringe other IPRs, so who would take liability, the AI itself or other stakeholders? Very often, we will see in practice a lot of, infringement created by or like attributed by AI. So liability is a core issue here that will remain unanswered until now. So hopefully Europe, US, Vietnam will come back, with an answer once the IP legal system will be amended or comes into effect. And the last one is can this concern be handled by the contract elaborating the rights and obligation of the shareholders? So in my opinion, that needs to be elucidated in project amending IP law, especially Vietnam, when we are amidst the process of amending the IP law. So the next thing is let's talk about the impact of the IoT on IP law and what is IoT. As you can see on the screen, a lot of things really interacting and really recollected or have a nexus with each other. Number one, I think for what we call about IoT, first of all, we need an infrastructure of network and physical objects. Secondly, that need to allow smart objects to interact and collaborate with each other. And the platform for the IoT, as you know, it will be internet, smart devices, information processing equipment, and device sensing equipment. So IoT actually requires smart object to collect data and transmit that data either to other devices or to a central analyst object. Later on, we'll talk a bit more about that one, but I think those are the devices that need to be interacted, connected, using internet or collect data and transmit data and really, to a central analysis, object. And next thing, I will touch upon the challenges to IP law. The challenges to IP law and subject matter eligibility. Well, when I attended the one of the workshops in Ho Chi Minh City, Nora was there. So one of the audience, the person coming from the top German technology company approached me and Nora, and he asked, hey lawyer, you stop talking about software cannot be patentable. You actually you locked the door for our company and many technology companies to file patent in Vietnam and elsewhere in Southeast Asia. Saying, of course, I told our one of our friends, attending my workshop in Ho Chi Minh City, that of course there are some exceptions in terms of software and how we can patent the software as a patent in Vietnam. Let me share with you some exception here under the Vietnam Ministry of Science and Technology Patent Examination Rule. So it actually provides that in particular an invention could be patentable if it has a technical character and is a technical solution for solving a technical problem by technical means to attain a technical effect. So it means that when you basically the software itself can be protected as a copyright under the Vietnam IP law and other laws in the region. But the question is how to make sure that a software can be patentable. Let me give you an example here. Like everyone is using Uber in US, a Grab in Southeast Asia, in Vietnam. So the software itself is not patentable, but if we found a software as part of the whole system, with the server interaction and with the interconnection with the smartphone and with the positioning technology technique, and then all in all, if we can be combined as a patent. So that's why, as you can see, that Grab and Uber, they all have the patent coming from software as a supporting part of the whole patent. So by and large, software invention is mere an abstract idea and claim under designation of computer program or software, that they might not be eligible for patent prosecution, but they can be patentable if it comes together with other technical solution, as I mentioned, like in order to solve a technical problem. So the software that Uber and Grab are using now in order for customers to interact with drivers and the server, actually they can be patentable. So again, software can be patentable if it comes with a technical solution and character. Okay, let's move to the next interesting thing about 3D printing and what is 3D printing and how that interacts with IP law. So Europe, as you can see that you guys are lucky to have a lot of big brands from the fashion industry like Louis Vuitton or Prada. So imagining one day you can buy a machine and the 3D printer can help you to print a Louis Vuitton handbag or a man bag or whatever. So it very conveniently. But again, two key issues comes up here. Number one, I have to say that 3D printing or additive manufacturing is a process of making three-dimensional solid objects from a digital file by depositing down successive layers for material until the object is created. So again, traditional manufacturing method, it includes like subtractive manufacturing. It's also cutting out, like hollowing out a piece of metal or plastic with a machine. So making printing a Louis Vuitton or a scarf, nice scarf from Prada can be easily done by 3D printer. So what about a cars or even helicopters or even a bigger machine, like something more complicated? I can say like a aircraft in future. So can 3D printer do that? I'm still hoping that something can be done, anything can be possible, but the key thing here is two key issues. Number one, the person, the patent holder, the company who created a 3D printer who can make a product like that, like a Louis Vuitton bag or like a helicopter or like a car. So actually they can own the copyrights over the 3D printer. They can really own a patent, the object with patented technical function. And of course, with the 3D printer itself, from the outside appearance, they can really own the industrial design. In the US, you say that the design patent. Vietnam, as a part of ASEAN, we call it industrial design. It's been the object ornamental and artistic appearance in the outside of the printer. And of course, if you brand your 3D printer, of course you can own a sort of a trademark as well. So that part, the first part, is about the 3D printer itself, or even the 3D printable 3D printer itself. But what about the 3D printable objects? So what about the products coming out of the 3D printer, like Louis Vuitton handbag or a helicopter or like a HP printer, even like we call something else like a car, like Toyota car, something like that, like Altis or like Camry or even BMW. So it's really hard to tell right now because we don't have a clear legal mechanism to deal with that. But I think 3D printable objects can become sort of like infringing products and infringing the IP rights of other IPR holders. So in fact, the current IP enforcement mechanism provide protection for an object being printed in 3D without authorization. For example, if an original object are copied and a 3D printed without authorization, and creator can obtain relief under copyright law. So what is the legal issue of the 3D print? I think this is quite a big question. I can tell you here some challenges. Number one, end user can download a file and create an object using a 3D printer. I think number one. Number two, the mean of production is decentralized. I think it's quite important. And then it's quite difficult to prove the infringement because who is actually infringing in here? So I think that's the key question. So a lot of unanswered questions still hanging over the head right now. So number one, 3D printer producer, cellular computer added, a design card file creator. Can they be considered as indirect IPR infringers? And are there an exception? That's the number one question, for everyone. So number two, can operator of a 3D printer liable for direct infringement? Is it easy to track infringers? I think that's really hard question as well. And the next question will be very challenging for lawyers, for law drafters, and for stakeholders is who would be the author of an object, like, applied artwork that is conceived, cut, graphical design, and 3D printed by different parties. Are they co-authors or not? I think those, I have to say that, after the few minutes talking to you regarding 3D printers, so my position is very confusing as well. So my hope is that in future, the law will be amended, not only in Vietnam, but also in Europe and other part of the countries, in order to tackle the issue, to make this unanswered question to be answerable. I think those are some of the fundamental issues that impacting on, number one, the AI, IoT, and 3D printing under the international Vietnamese law and best practice. So I think I can go a little bit fast, but I can stop it here and open to any question you may have to myself and Professor Alexander. And I think I just pass it here, Nora. Over to you.
Thank you very much, Hung. It was
Nora?
a very yes. Can you hear me? Yeah, right. Yes.
Roger.
Thank you. Yes, thank you very much for your presentation, Hung. It was very interesting, and I like that to finish it with the 3D printing topic. It brings a lot of questions, and actually we were also approached by some colleagues in Singapore to see if we can also do later on a specific webinar on that topic, because it seems to be from IP point of view also very interesting. So let's see. But I have good news for you. We received quite a few questions, so I really hope that our speakers are still available to stay a bit longer and discuss with the audience. So one of the first questions for Professor Wurzer on is more like a little bit of a clarification related to the first presentation. If the discussion was only related to, I assume that the question is on the case study, if it's only related to the European patents.
Not really. So the taxonomy is done based on PCT applications, European patents, and US patents. So we try to make it as international as possible.
Okay. And the other one was on how we can define the scope of standard essential patents in the area of Industry 4.0 and digital transformation.
Okay, that's another very interesting and big topic, and it should be discussed in a specialized webinar just on that issue, because that's for itself again a big thing, because of the interoperability and because of the importance of SCPs. It should and standards within the digital transformation. It should be discussed separately. So it's not done with 1 or 2 sentences.
Yeah, so we can do a follow-up session maybe in 2021 and go into more details on this topic. So moving forward with the question, there was one question to Mr. Hung on the patent application. Basically, the question was related to why there is such a big gap between the Vietnamese locals who filed application compared to the foreign applicants. If you can give some explanation on that.
Right. Well, thank you for that question. Let me give you a context here. Number one, because of the IP awareness in Vietnam is still not very high. We are still doing a lot of effort in order to bring Vietnam up to speed. Number two, as you can see that a lot of Vietnamese engineers, they are multi-talented, working in Google, Facebook, and many parts of the world, in Korea as well. They do file a lot of patents internationally, but they do file under their company names. So I think somehow we cannot underestimate, the technology effort and the innovation coming out of Vietnam. But actually, we call it a hidden charm. So hopefully they will come out, out of the dark in future and do more. But national filing is still very humble, because actually the cost is still quite significant. So that's why I think that's the reason why.
Okay, thank you, Mr. Hung. And there is another question to you on the pen. If you may have information on that, or through the IP cases you followed, if you are aware of any pending cases in Vietnam concerning the ownership of a patent created via artificial intelligence.
Oh, can you repeat the question again? I'm sorry, Nora.
Yes, if you are aware of any pending cases in Vietnam where basically the ownership of the patent was created through artificial intelligence.
Oh, I'm not aware of any pending cases like that in Vietnam right now. But I can tell some good news. Vietnam actually started having some PPH with other countries like Japan and Korea. I think that will help to facilitate the patent prosecution in Vietnam as well.
Okay, thank you. Another question, which is, I think, can be addressed with both speakers, so you may both want to share some ideas on that. How to protect your IP assets when you ask a customer to provide input and ideas to improve or upgrade your product or service through a customer support or spontaneous feedback, as we can consider that this is part of the digitalization process.
I can start first, or otherwise Professor Alexander and can start first. And either way will work for me.
You start. I don't really know what to say.
Okay, thank you, Professor. Well, from speaking for my part, I think in order to do so, number one, start with some basic principles of the IP rights. Of course, filing a patent innovation is quite time-consuming and sometimes costly as well. But consider some simple steps by protecting your trademark, your brand name, and your copyright, and even your industrial design. Very often we have been working with startups in Vietnam, and we support them to file a lot of trademark. The reason why people keep saying that it's really hard to buy or invest into a factory, but you can spend about a few $100s in order to file the trademark. And in future, if the trademark becomes famous or well-known, and then you can commercialize it. And of course, for startup, a lot of young engineers, are working on new software system. And of course, as I mentioned in my presentation, software itself is not patentable. They can be protected by copyright regime. But again, software very often can be patentable if it comes with like a technical solution. And like, Grab or Uber, as I mentioned, they are actually working on that, and it's quite interesting cases.
Okay, let me say the following. First of all, when you look into the patent law around the globe, we have there the sentence, software as such is not patentable. And the as such is the cornerstone, and unfortunately quite often forgotten. So, and as such, nobody wants to file a patent for software. This is a work of literature. That's not what you want. Is you take the software, put it on a computer, on a machine, and then it's doing something. And this is patentable, of course, as long as it is new and inventive. And that means that too often, that's my experience, too often digital experts stand away from thinking about patents because they heard something like software is not patentable. Yeah. This is wrong. Software as such is not patentable, and that's important. So that's the first thing. The second thing is that many digital experts mean just because it is creative what they did, it is patentable. That's typically wrong. It is creative, but unfortunately, it does not fulfill the criterion of being new and inventive. That's something different. Creativity is creativity. That's good. Why not? But when you want a patent, you have to fulfill certain regulations. And that means once it is your objective, having something exclusive and protected via a patent, you should first think about what happens when I have a patent. Is it really enforceable for me? Can I detect infringements? Why do I really want a patent? Okay, and that's a good question. Not can it be patented? Ask the question, do I really want one? And for what? So, and when you ask that question, it is good to think whether what is your economic benefit by investing in such a thing? For what? Do you want to impress, to signaling to your investors? Do you want to attract bright people because you are so inventive? I don't know what your reasoning is, but it is important that the investment in IP is an economic decision. And that means you should behave rational in terms of what will be your benefit once you have it. So, and not just having one because you are creative, or you want, maybe you want just a stamp on your creativity, and that's why you file a patent. We see that around everywhere. You should think about that. And when it is really your objective that you need exclusivity for something, okay, and even especially once it is digital, use the patent literature, read it, look what is a comparable problem and a comparable solution, and look at it and try to learn how these guys have described their issues to make it patentable. Patentability does not come for free just because it is a creative solution. That's not a good way of thinking about that. It is work, it is hard work to make things patentable, and that is an investment, and it should be made clever and smart, and not just hoping because something is creative you could patent it. You have so many degrees of freedom once you do something digitally, that it is good and smart to learn from others. That's why we publish patent literature, to give the information how it is well done, and what is rubbish, okay, what did not work out. So that's a strong recommendation, that we have so many degrees of freedom to create digital solutions. Use the ones which can be patented. So sometimes people rush in my office and says, "Hey Alex, I have this app. Can we patent that?" I don't believe that. Not because you cannot patent apps. I don't believe that because this app is not designed in a way to be patentable. And when you want to learn how to patent apps, you can go into our seminars. But just as an example, look at Shazam. Shazam is an app, and it has more than 200 patents which protect Shazam. Of course you can patent that. Where's the question? But you have to do it right. You have to design the object, so the digital solution, in the right way. That's my comment to that.
Thank you very much for sharing your point of view. And well, I think we can close the Q&A session with an open question. If our speakers think what will come after digitalization, is there any future step that we can think about today in 2020?
Okay, this time, Manh, I would start. Is that okay?
Yeah, please go ahead, please, Professor.
Okay, so what I'm saying is, I don't understand the question in terms of what is after digitalization, because digitalization. So it's a little bit like what comes after using energy So we can just say which kind of energy we use, which kind of energy source, but that human needs to use energy to get certain work done is a fact of physics. And so I don't believe that the general solution to use digitalized data to solve problems will go away. It's the same thing that I don't believe that we use something else than electricity in the future. The question is how we produce electricity and how we transport it and transform it. But the physical fact that electricity is a smart way of using energy don't goes away anymore. I don't believe that. We will see the usage of light for transmitting data, all that things. We will see quantum computing. We will see a lot of, so even 2020, it's very close. we will see that computers are vanish, okay, that we don't see computers anymore, that the term computer makes no sense anymore. It's like the same thing like today, that you have to restart a computer, okay? So I don't know when you have last time to restart your mobile phone, but typically people get nervous when they have to restart a mobile phone, because mobile phones have to be on and have to be online, and otherwise this gadget makes no sense. So this is a way of thinking that we will come in we are very close in a world where we don't see computers, we don't feel it, but they are there, and the objects, like our headlights today in a car, or the clutch or so, the gear shift, it is simply doing what a gear shift is doing or what a headlight is doing, and we don't think that there is a lot of computer power in it to make that happen. We don't see it, we don't call it computer. And I would say this is the next step. The next step is the smartness of everything, and we just expect that a window knows what a window has to do, and that a window is not that stupid that when the wind blows in or the rain comes, that the window is not closing. Okay, so we will expect smartness everywhere and from everything, and that will change our life completely, especially the business. And coming up with that, and with 5G connectivity and with AI on top, nothing will be the same like today. That's very simple. But it's not after digitalization. It is a part of it. Like today, we live in a world within the Industrial Revolution. It's not gone. It's simply the next phase, and we are in the middle of that. That would.
We are heading there already. Thank you very much, Professor Wurzer. Mr. Hung?
Yes. Yeah, for my part, I can speak very briefly on here. It's really hard to envision with uncertainty what happened next in the next few years, in next 10 years, or many years to come. But I think the quantum computer, as Professor Alexander mentioned, will no longer have the same meaning as it used to be. For me, two key things will be critical in the next few years or many years to come. Number one, Internet of Things. It will be becoming a big thing in future. So anything comes with Internet of Things will be quite a critical interfacing with life, work, and even with how we interact with people and machine and devices. Number one. I think number two, about data. People keep talking about data. Data is, I think, the property, the key thing that will become really critical for businesses and people, and comes with that. I think privacy will become an issue. So that's why you can see that now China adopted for the first time the Personal Data Protection Act, and Vietnam is working on the same thing. So I think those are the key things that will become the FUNCOM, the core thing in future.
Thank you very much, Mr. Hung. I would like to say thank you to both speakers today. It was an excellent webinar. Thank you for sharing ideas, and let's explore other sessions that we can do together in the future. So thank you for Center for International Intellectual Property Studies, also Pamela and Tobias, for collaborating with our team in organizing this webinar. We will. Yes, please.
I'm allowed to say something in additional?
Of course.
In the lockdown here in Germany, we have a joke, okay? And the joke is that the psychologist tells you it's not a problem when you start to talk with things during the lockdown, okay? It starts to become dangerous when you think that these things are answering. And I would say, according to your question, then you are in the Internet of Things.
That's true, absolutely true. And I hope the lockdown will be soon, removed or eased in Europe. We hope everyone will stay safe and sound.
Okay, stay safe, and thank you very much.
Thank you very much. Thank you for the participants, and keep an eye on our next webinars as well. So hope to see you again. Thank you.
Thank you so much.
Bye.
Bye.
Bye.